First, I want to thank Dean Paul for the kind invitation, and Megan and Brad and Stacy Velarde for all the coordination and the work to set this up. After graduating Northeastern University, class of '83, I began my career in the Enforcement Division of the Securities and Exchange Commission in Washington, D.C., and participated in the investigation of certain insider trading cases, Dennis Levine, Ivan Boesky, Michael Milken, and other cases, and learned a lot of skills that have helped me in policing, helped me in this decades-long fight for justice. I learned to organize a lot of documents, and let me see if I can make this work now. And here's a slide with a pile of documents, which is how normally we received them, and then we had to organize them. And these were complex investigations, and learning these skills have proven their worth over the years. So my family has a long history in Germany. Fortunately for me, many in my family escaped Germany during the Nazi era. Unfortunately, my grandparents and my father passed away before I was 8 years old, and I grew up with little knowledge of the German language or our history. Starting in 1990, in relevant part, the reunified Germany opened up to Jewish victims of Nazi discrimination and their ancestors the right to pursue claims to recover or receive compensation for property stolen during the Third Reich and located in the former state of East Germany. In the 1920s and 1930s, my extended family had real estate interests in and around the city of Berlin. From the beginning of the Nazi regime, the family had those interests stripped from it through a series of anti-Semitic actions and laws. Since 1991, actually, I've been pursuing restitution for what in effect is an entire village named Seehof, located in Teltow on the border of Germany's capital, Berlin. And here is a Google photograph. Here's the border between Berlin and Brandenburg, and here's the Teltow Canal, and this entire area was the area that was owned by my family, extended family, and we'll spend a lot of time talking about some of these places, but as you can see, it's all subdivided and developed. In Western terms, it's roughly 200 acres. In this campaign, my sister and I share the claims for the parcels with the heirs of other surviving members of our family. And before moving to Berlin, I used to visit Berlin 2 or 3 times a year when I worked at the Securities and Exchange Commission. And through this process, I met my wife, a German woman. We're soon to be divorced. However, it's relatively amicable. We have 2 children, Alexander and Rebecca, and I want to dedicate my talk today to my children and to my soon-to-be former wife. Counsel for the former East German town of Teltow and certain courts of the state of Brandenburg have seemingly ignored the cold, hard facts of Nazi discrimination and instead have acted as though the expropriations happened in some imaginary history. Against constant opposition, we have succeeded in recovering most of the parcels after fighting against repeated trial-level rejections, followed by successful reversals in the appellate courts. After reunification, we litigated for 12 years before the government before we succeeded decisively. We have settled with the federal German government and for the most part have been able to close out the past with justice. However, in a recent set of decisions that are legal in form and unjust in real terms, Germany's courts have denied 10 building permission applications And we have been through the entire court system, and we will appeal those denials to the European Court of Human Rights. However, on the other hand, I'm happy to report in the past month, our struggle was capped by several successful appeals that resulted in the removal of certain judges, the reversal for the 5th time, that's 5 times, for their negative decisions trying to deny restitution, and affirmation of restitution on certain large parcels. So let me tell you how all this came about. Here is a photograph of my grandfather and grandmother. The brothers Max and Albert Sibursky in 1872 bought Seehof. Albert had one daughter, Susie, who was my grandmother and mother of my father, Hans. And Seehof was originally a farm, and in 1933 the estate comprised of family villas, a formal park, as well as farmland and limited residential development. The then owners were all Jewish and worked as lawyers, businessmen, and bankers. Among these were the successful businessman Paul Mamroth, who served on various boards. Several members served in the German army during World War I. My grandfather, Arthur Sonnenthal, was a decorated officer. My greater extended family were completely integrated members of German society prior to the National Socialist period. They recognized in time the need to flee and disperse to England, North and South America. After my grandfather passed, my sister Valerie and I inherited one half of the ownership of Seehof. Heirs of the original owners of Seehof filed comprehensive restitution claims, and these claims have been under administrative and judicial consideration for the past 23 years. So let me explain the historical context. This is a slide which attempts to at least outline the various German states that have existed, and these states have taken many forms. There existed the German Reich from 1871 until 1918, thereafter the Weimar Republic until 1933, then the National Socialist dictatorship state from 1933 until 1945, when Germany as a reunified state ceased to exist. After military occupation in 1949, the West German and East German states, and for the past 25 years, since 1990, the new reunified German state. In 1871, Jews were granted full rights of German citizenship. In 1872, my ancestors purchased Gut Seehof. And here you have a very interesting slide, which was a map. It's a close-up from 1874. Here's Seehof. This is clearly a farm. It's next to a sea, Teltower See, and it's not residential. There are fields. So in 1870, let me just continue with the slides. This is the full slide showing Teltow and the region, which has now all become a suburb and fully developed. When the National Socialists took power in 1933, the roughly 500,000 German Jews made up less than 1% of the German population. Seehof is a suburb of Berlin, located next to the Teltower Lake. Because there have been repeated judicial decisions denying restitution, we have had the time and necessity to research all relevant aspects of the Third Reich in Teltow and Seehof. Here in 1925 is a photograph of my father. And this villa was not part of the real estate development that I'm discussing, but it's located in Seehof. This building was stolen by Shearing Corporation during the Third Reich, and we successfully litigated for its return in 1994, and subsequently, in an effort to settle all claims, received beneficial zoning for the development of the surrounding land. Unfortunately, my co-claimants opposed the first effort at a global settlement. Thereafter, Teltow also has refused to settle. Beginning in the early 1950s, the West German state established a framework for restitution, and victims of Nazi persecution were allowed and did recover stolen properties. But throughout the existence of the East German state, no restitution was permitted. Here is a slide which tries to capture some of the drama of the fall of the Berlin Wall and the events that have occurred since then. In 1961, the Berlin Wall was built, and movement between East and West Germany restricted until 1989, when the crossings were opened and the wall fell, leading to, in 1990, formal reunification and the creation of one democratic Germany, the first time that this has existed since 1933. This year, 2014, Germany and the world mark several milestones: the 100th anniversary of the start of World War I, more directly the 25th anniversary of the fall of the Berlin Wall, and the beginning of a new, reunified Germany. Indeed, I submit that 69 years after the end of World War II, this case illustrates that German society is capable of both good intentions, good laws, and good faith work. Yet, from my point of view, unfortunately, the history of this litigation shows that the best laws and national goals can be undercut when those who carry out such a process do not share that commitment. So, how do you go about researching such cases? This is in some respects, directly relevant material for a law student body. And until 1991, I had never given a lot of thought to what had happened in Seehof. Since then, it has been a long process of research, especially in the beginning. We have not had the cooperation of many parties who possessed most of the evidence. We have had to revisit archives repeatedly, slowly discovering new leads and demanding that documents be shown. In no way can this be likened to discovery as practiced in America. In the words of Ben Bradley, the truth does emerge. It takes forever sometimes, but it does emerge. And let me add, sometimes by luck, but always by persistence and determination. The pursuit of these claims has proved no simple matter. Witnesses are generally long dead. Records, maps, and backgrounds of the persons involved in the expropriation of properties had to be dug out of archives, old correspondence, and municipal records. Facts and inferences needed to be pierced together painstakingly in an unfamiliar country with decades-old material in a language I did not fully understand and in locations where, as I've said, few had any motivation to assist. So here's a hint, if you will, of what's involved in researching these cases. We began by proving inheritance and prior ownership. And wherever located, all historical archives were researched. There were no shortcuts. All leads were run down. As new books were published, I continued to read personal memoirs in the secondary literature. A chronology of events was made so that an accurate narrative was created. Chronologies also highlight relationships between contemporaneous events that sometimes proved important. And it gets more complicated as you begin to learn what happened. You start to see leads everywhere, and running those leads down is what we are discussing. In the 1980s, when I was investigating financial fraud, I used to have a 5-minute rule, which was I had to be able to find any document in my possession within 5 minutes. So creating an index, and then an index, and then an index of indexes, that's what we used to do. Now I suppose it's all scanned and digitized, and at least while the electricity works, you'll be able to find your documents. In the lower right-hand corner is one of my favorite phrases: make delay work in your favor. And people who are defense counsel will understand that, and prosecutors need to understand it as well. Where persons who acted during the relevant time were alive, we interviewed them and prepared affidavits. Maps proved to be an invaluable resource. Changing details on the map showed when and how land had been used and expropriated. Every relevant historical document was reviewed, copied, and assembled to prove the relevant elements and to tell our story, until the last appeal and the last case are finished, I believe that research is never complete. There are always more leads to follow, and doing so is worthwhile, albeit time-consuming and expensive. Facts win, and without the facts, no good law will be enough. Of course, there are attorneys involved. I recognize that to win a marathon, we had to control costs. Because we have faced hostile judges and many others opposed to settling our claims, we were forced to find strategies that allowed us to fight for decades. One of these strategies was not permitted in Germany, namely contingency fee agreements. Of course, some attorneys have bought claims from their clients, and that was legal, thereby having enough incentive to work for years without pay. But in these cases, we had a unique set of circumstances because roughly 500 parcels were developed and occupied by tenants. And because I traveled to meet with community representatives and residents of Seehof, I recognized that as Jews returning to Germany to reclaim our property, there were many persons who had lived miserably under communism, and we should not add to their suffering. So most Seehof residents paid rent to the East German Teltow administration, and in many cases improved their homes. So we designed a settlement program that allowed persons who had resided in Seehof under communism to purchase our claims at a steep discount. And most did not, because they believed that our claims were baseless, but enough did so that we could fund our litigation costs. So let's turn to the law. Briefly, here's an outline of the German legal doctrines that apply when Jewish victims and ancestors of anti-Semitic persecution during the Third Reich attempt to recover stolen property. My focus is on real estate. Under German jurisprudence, the Third Reich is divided into 3 periods. The first period from January 1933 to the passage of the Nuremberg Laws on the 15th of September 1935. The second period from then until Kristallnacht pogrom on the 9th and 10th of November 1938, and the third period thereafter until the defeat of Nazi Germany in May 1945. Here are the legal elements for a real estate sale. And I'm basically going to read this because there's no other way to say it. The law assumes that all sales by Jews during National Socialism were made under duress. Second, can the buyer challenge the assumption by proving that the sales price was appropriate and that the sales proceeds were paid and freely disposable? 3, were there any other facts proving or indicating duress so that the buyer's proof is irrelevant? And for the second and third periods, that is from September 35 until the end of the Third Reich, the buyer, in addition, has to prove that the sale would have been made absent the Nazis being in power. I believe the different treatment of the first period by courts in the law is questionable and in many respects not consistent with a fair reading of history, but discussing this comprehensively is beyond this talk. And to make matters worse, in restitution cases, there is no appellate instance for the review of the factual record. Under normal German law, there exists an appeal court step to check and introduce new facts. So let us review the facts. Seehof was a farm, a commercial farm. And here is a photograph of my grandfather in 1922. And Kartoffel, for those who know or don't know, is potatoes. And that's his potato dealing license. And in 1929, the Seehof farm, held 24 cows, 24 pigs, and 15 horses. From the 1930s, before the Nazis took power, we have photographs of the barns, the sheds, the cows, geese flock. Clearly this was a business and not merely a land development holding. And these are the sheds. Here's some geese, and let's take a closer look. What's interesting is the handwriting. I mean, pictures of cows are pictures of cows, but actually these are cows in Seehof. And there's some geese. So, this is a very interesting map. It's from 1890. Here's the date. The Teltow See still exists. That's the farm compound we just looked at. And here is a proposed real estate development, not on the farm. That's 1890. So here's an updated photograph now from 1927, 37 years later. And it's flipped, but here's the farm compound. Now Teltow Say has become the Teltow Canal. This is the border of Berlin, by the way. And the proposed real estate development is still confined to one area. The farm continues to exist. Finally, this is a 1934 aerial photograph which shows the beginning of the transition from the farm to the real estate development. There's the compound, and here were the fields we were looking at, and you can begin to see houses starting to be constructed. From this 1934 aerial photograph, the farm compounds, equipment sheds, and fields for crops are still visible, as well as the beginning of the new housing subdivision. Even so, counsel for Teltow and the courts disputed whether Seehof was a commercial farm. Rather, they argued that because of the facts showing some future limited building plans, they asserted that the entire area was held for development, and this argument trumped all other facts. This argument was false and misleading, and indeed a bad faith invention designed to deny restitution. We proved that areas proposed for development prior to the National Socialist period were primarily along the Teltow Canal. So, what happened? The program of the Nazi Party was revolutionary and anti-Semitic. It called for the removal of Jews from the economy and from Germany itself. Upon assuming power in January 1933, the Nazis imposed their program by law and by violence. It is beyond this talk to discuss these events in a comprehensive way, but we need to recognize that historical study requires that we attempt to relive in our minds the experiences of the past. And there are two methods to this exercise, one truthful and one driven by a preconceived agenda. If you only look for facts that will support a predetermined outcome, history will be incomplete, misleading, and mythical. If you consider every fact with an open mind, you may imagine what really happened. Repeatedly, in these lawsuits, the courts in Teltow have chosen to present only those facts which they believe support their efforts to deny restitution. Here are some of the facts known to the courts in Teltow, and one can imagine understood by the Jewish owners of Seehof. They knew in 1927 the Nazis were active in Teltow because Dr. Goebbels spoke there. And we've added this circle here because it shows that this is in Teltow. Here's Dr. Goebbels speaking on the choice between Lenin or Hitler. During 1933, my ancestors knew that everything they worked for was under the threat of expropriation, that their friends and colleagues have been or were in the process of being forcibly removed from their jobs and their careers destroyed, that the democratically elected mayor of Teltow was replaced by a Nazi, that the main street in their estate, once named after their ancestor, Max Sibursky, was named after a powerful Nazi, Wilhelm Kuba, that the boycott of Jewish businesses in April 1933 was directed at them and followed by worsening conditions. That in Berlin, during June 1933, Jews were beaten and at least 22 persons died in the so-called Berlin-Koepenick Bloody Week. That the property of communists was being, quote, lawfully, unquote, confiscated, and that every Jewish aspect of life in Nazi Germany was under attack. And on the 22nd of August, 1933, the Nazis marched through Teltow, as you can see. And on September 29th, 1933, there was direct interference in the property rights of my ancestors, whereby the so-called Erbhof law, or farm ownership law, provided in relevant part that Jews were excluded from all German farming associations and related subsidies. 2 weeks after the passage of this law, my family entered into the contract to sell all of Seehof with a Nazi real estate agent named Wilhelm Gloatz. That contract was dated 13th October 1933. After 60 years of ownership, the farm was to be sold. This led to the 16th of May, 1934 master development contract with Teltow for a planned 1,000 parcel garden city. And here you can see the plan. And it is from August 1935 in Seehof. And these are proposed streets. This is the farm compound we've looked at. The original proposed limited development was along Teltow Canal, but now every field, every place is going to be subdivided and turned into housing in a garden city. I believe that my ancestors were rational and that they made the decision to sell Seehof under the duress of the Erbhof law. Why else sell the farm? The legal point is that if a court had found this to be true, that is, that the decision to sell was made under duress, then a global positive decision would have been appropriate, thereby granting restitution for all subsequent sales. We submitted the Erbhof proofs as early as 1996, and there can be no doubt about the anti-Semitic elements of the Erbhof law. The Nazi Party controlled Teltow. The architects hired to design the garden city were Nazi Party members, as was the real estate agent Glowacz. Advertisements for the sale of the parcels were placed in Nazi newspapers, and then the sales began. And here is a slide which shows you the actual sales, which totaled over 500 homes and parcels. So, in addition, Teltow received, in exchange for granting future building permissions, almost 30% of Seehof for parks and streets, plus land grants to the local church and school. Well, it all seems pretty straightforward, doesn't it? But it isn't. And here's what has happened since we filed the claims. I'm not going to discuss, or I will cover the highlights and not discuss every stage of the administrative and judicial process. If we knew in 1991 what we know today, I dare say the results that I'm about to explain would have turned out differently. But because of an incomplete historical record and the court's refusal, repeated refusal to accept our evidence, the first decisions were wrongly decided, and the consequences of those mistakes continue to impact my family to the present. So, the fun is over. Now comes the history of the litigation. And this slide basically gives you an overview of what we've been through. In 1991, we filed the claims, and after 5 years of administrative hearings and lower court decisions, the global negative decision by the AROF, an administrative agency representing Germany in restitution cases, was issued. It was confirmed on appeal before the second administrative instance, the LAROF, and later in 1996, the Verwaltungsgericht, or lower court, by judges Wilfried Hamm and Peter Pfennig. They split the pending claims into 1,000 single cases and then picked representative cases and affirmed the global negative decisions denying restitution. I refer to the whole group of early decisions as the global negative decisions. They denied all Seehof development restitution claims for all 3 periods of the Third Reich by basing their reasoning on the finding that the decision to sell Seehof was made freely by a series of assumptions and the selective use of facts they constructed a fiction. All facts about the persecution of Jews were reduced to irrelevance because the court found that the decision to sell was made freely due to the fact that there existed maps showing plans for development. The lower court decided that all subsequent events in connection with each parcel were irrelevant, except to the extent that it had to show the general sales price was appropriate and the proceeds were received. The judges ruled that the decision to deny restitution was final, and because of due to its findings, there was no need to address the history of later events. Again and again, the lower court decisions engaged in a series of illogical assumptions, ignored all other facts, and summarily asserted requirements to defeat restitution. To give one example, the court asserted, quote, "It could be assumed that the intention to subdivide and to sell the farm has already existed before the National Socialists had come to power." From this assumption, the court concluded that the decision to sell was made, quote, slowly, unquote, and freely, unquote. The actual historical circumstances were not addressed in detail, and if at all mentioned, merely in an effort to dismiss their particular relevance by the repeated assertion of the general assumption. And if this sounds thick, it is because it is. If you've ever read a German legal decision, it's like working your way through a swamp. But at least there's dry land on the other side. Worse, the decisions assumed that because my ancestors did not claim certain wrongs, they did not occur. Aside from the faulty logic of proof, the facts were that my grandparents in 1947 complained. And here's a slide with a quote from the family representative in 1947 saying that Teltow shouldn't use the villa you saw earlier, and in the same letter was the statement that they were forced to sell the villa and Seehof because of Nazi persecution. In individual cases, the global negative decisions were overturned by the appeals court, the Bundesverwaltungsgericht, in part and infirmed in part in 1998 in what is called Teltow-Seehof 1. So each Teltow-Seehof is a higher court reversal of lower court decisions. However, because the factual record was not fully developed, the higher court ruled that the global negative decision's reasoning was not correct. But they did affirm that the decision to trade 25% of Seehof was made freely because the heirs entered into development contracts with Teltow and Glowacz, and they received the possibility of building permission on the remaining parcels. This finding meant that Teltow did not have to return the land given to it for streets and parks nor pay compensation. In 1998, we were not aware that the actual land granted to Teltow was almost 30%. This we discovered in later years. Teltow-Seehof 2 was decided in 1999 based on our appeal that Judges Hamm and Pfennig had not issued professional historically true decisions. Again, Judges Hamm and Pfennig had upheld the denial of restitution, had refused the heirs the right to appeal. This is really truly unique. In Germany, you can be refused the right to appeal, and then in order to get to the substance, you have to overcome the decision that denies you the right to appeal by proving procedural errors. Well, in reversing these decisions concerning individual sales, the appeals court ruled that our rights had been violated because there were not sufficient facts in the opinion. The facts were superficial. The judges failed to distinguish between the three periods in their reasoning, and there were wrongful conclusions based on these flawed facts, and the cases had to be returned to the lower courts for factual development, and expert opinions were required on the adequacy of sales prices. So, after this reversal, we obtained the expert opinions necessary, and in the course of this 20-year saga, I really can't believe it's this many, but it's almost 20 expert opinions we've obtained, but we have. And during these many years, we proved in detail that the heirs were victims of anti-Semitic persecution in their own careers, and all but one fled from Germany during the 1930s. But regardless of the proofs and expert opinions we submitted, Germany continued to oppose, and in 2002, Judges Hamm and Pfennig again denied our restitution claims and our right to appeal their negative decisions. So in 2003, we succeeded in Teltow-Seehof 3 to overturn their decisions for violating our rights. The higher court pointed out that Judges Hamm and Pfennig had wrongly concluded that the decision to sell Seehof was made freely based on Teltow-Seehof 1. The court outlined 3 violations and then went so far and said the decision to sell Seehof was actually made under duress. But please note the ruling was limited to the pending cases. It's not a precedent in the sense that we would understand it. So to the extent it was applicable in the future, it would have to be part of individual decisions for each parcel, and the losing party would have the right to appeal. And with regard to that, all parties who were on the losing end had certain rights. For example, the heirs could not receive ownership of parcels sold to the few buyers in good faith. In certain cases, due to quirks in the reunification process, the heirs were barred from restitution but could obtain compensation. Teltow, the nominal owner, and other persons occupying the disputed parcels had the right to appeal the restitution decisions. In 2004, the federal government of Germany entered into settlement negotiations. We concluded a settlement with Germany in 2005, and administrative agencies representing Germany began the process of issuing favorable restitution decisions. In 2006, Teltow decided to appeal against Germany, and with the help of Judges Hamm and Pfennig, found a way again to delay the resolution of these matters. Judges Hamm and Pfennig delayed confirming clear-cut cases for at least 5 years in an attempt to force us to compromise on terms favoring Teltow. In 2013, they confirmed those 2006 decisions, and last month, Teltow lost its final appeals. Consider for a moment that Teltow, with the help of the judges, were resisting against the heirs' settlement with Germany. The parcels at issue were once taken from the heirs by the Nazi administration in Teltow. The parcels were part of the original building parcels promised to the heirs in exchange for giving Teltow the streets and other land grants. Throughout the years, we've continued our research. We learned that the laws for real estate development limited to 25% the amount of land that could be demanded from the owners. We returned to the local archive repeatedly, and we discovered that the Teltow archive held relevant historical evidence that Teltow had not volunteered. From this evidence, we proved that in our case, the 25% threshold was exceeded because of forced land grants to the local church and the school, and that was a violation of both normal practice and the then existing development law. In my view, this example of unequal bargaining power, showing an obvious land grab, should have persuaded the court that the factual predicate was satisfied to require the greater burden of proof for the first period sales. By 2009, we proved in great detail that Teltow got 29% of my ancestors' land in perpetuity. Despite the growing evidence of duress, Judges Hamm and Pfennig held back deciding clear-cut appeals, and instead again ruled that the heirs did not have the right to appeal certain first-period cases. In 2011, in Teltow-Seehof 4, we succeeded again in having the decisions of these judges reversed and sent back to them for new decisions. The reversals were based on the same kinds of violations, failing to consider evidence, false assumptions, and unreasonable limits on the review of facts. In 2013, it sounds like a broken record, I know. In 2013, Judges Hamm and Pfennig again issued decisions denying restitution and the right to appeal. We appealed. So, let's consider Judges Hamm and Pfennig in context. Instead of speedy justice, these judges have caused many years of delay by abusing the provision that courts are allowed to deny the right to appeal. That provision's purpose is to provide for a speedier resolution of restitution claims. And we had to prove technical errors to overcome that hurdle and so that the merits of our appeals were heard. In many briefs, we proved repeatedly in detail with contemporaneous documents unusual and damning historical events. First, the terms of the development contracts were unfair. As we've discussed, this was proven by the fact that the government demanded and received more than the permissible 25%. Second, another provision of the 1934 contract granted Teltow the power to change the terms of the contract without the consent of the sellers. This provision alone should have been sufficient to prove duress, but the court did not accept our point of view. Third, that provision was actually used in 1935 to make an unfair forced exchange whereby land promised for building of 182,000 square feet, or 17,000 square meters, was exchanged for 85,000 square feet, or 7,900 square meters, in effect, a loss of 96,000 square feet, or 9,000 square meters, because someone complained about their garden. Judges Hamm and Pfennig ignored the general relevance of this proven anti-Semitic land grab. Fourth, the actual sales price per square meter was below fair market value. Again, despite having submitted well-documented briefs and expert opinions, Judges Hamm and Pfennig have refused to acknowledge this and instead have repeatedly attempted to assert that during the first period the sales prices were appropriate. There's simply no proof that the development of Seehof was conducted with special consideration for the rights of Jews. Consider that there were one set of contracts governing all sales. There were Nazi administrators that governed Teltow and Seehof, and their actions were consistent with the Nazi program. If they were not anti-Semitic, that would have been exceptional, but there was no sign of that. Neither Teltow nor the court has brought forth new facts or discoveries of a unique history in Seehof. We continued our research and time and again proved that Seehof and Teltow were typical Nazi localities where the anti-Semitic doctrines and unlawful practices of the Nazi program were fully implemented against all opponents and the local Jews. This history was supported by research conducted by local historians in 2011. They published a catalog surveying the tragic fate of Teltow's Jews, of Teltow's Jewish citizens. Without providing any contemporaneous documents or testimony, Teltow stuck to its willfully ignorant view of its own history. In one brief, the town council argued that Teltow was too busy persecuting social democrats and communists to bother with the Jews. I can't make this up. Here is an example that I submit reveals the moral bankruptcy and true motivations of Judges Hamm and Pfennig. In 2011, the higher court issued Teltow Seehof 4, in which it reversed Judges Hamm and Pfennig's rejection of the consideration of an expert opinion because it was merely not signed. The higher court noted it was an oversight that could easily be corrected, but Judges Hamm and Pfennig used this as an excuse to ignore the truth. The higher court ruled that failing to consider the expert opinion was a violation of due process. However, even after the reversal, they did not accept the contents of that. We concluded that Judges Hamm and Pfennig were not professional and that they abused their fact-finding duties to distort my family history, and we formally asked a higher court to remove them. In America, the proof of their bias, based on the fact that they've been reversed 4 times for violating their duties in connection with these cases, is obvious. But in Germany, the standard for their removal is based on the idea that their continued work on these cases may adversely impact my opinion on the German courts. And I just make a personal comment. As you might imagine, my opinion of them was extremely low, and if you look back into the history of this case, you'll find out that I was convicted of criminal slander some years ago, but I had no criminal intent. My attorney was with me criticizing these judges, and it took my attorneys quite some time to discover the provision that they used successfully. So in November 2014, in Teltow Seehof 5, we succeeded in having Judges Hamm and Pfennig removed from future involvement in the pending cases, and their latest decisions were overturned, primarily because of their failure to consider directly relevant evidence, some of which we've been submitting again and again for almost 20 years. By their repeated and deliberate rejections of all direct evidence proving local anti-Semitic persecution, they have abused history, misled the public, and aside from costly delays, inflicted great damage on my family. So, even when restitution is made, Teltow controls whether the fair market value of the parcels will be returned. It remains for the Teltow mayor and parliament to deal in good faith with its Nazi and communist history. Instead, the mayor and the parliament have used zoning against my family by designating historic building land as forest and nature preserve, and by excluding numerous other parcels from building areas, all to the effect of denying real justice. And here is one half of a map. It's showing where building land is. And in this lower section right here are 10 parcels. And I'm going to discuss those in detail because of what has happened. Recently, the Federal Constitutional Court, Germany's Supreme Court, rejected our appeals for building permissions on those 10 parcels without stating any reasoning, thereby letting stand a lower court decision. And if you recall, in Teltow Seehof, a suburb of Berlin, in 1933 and 34, certain contracts were made under duress, whereby approximately 30% of the owner's landholdings were granted in perpetuity to Teltow in exchange for building rights. These 10 parcels were zoned as building land due to those contracts. They were sold as building land during the Third Reich, and the sales proceeds were confiscated. To this day and forever, Teltow enjoys freely the land exchanged by the heirs, ancestors, in the unfair contracts from the Nazi period. The 10 parcels in this dispute, through no fault of the heirs, became part of the Berlin Wall death zone. And the other half of this map shows more areas for development, but let me just jump ahead. This is a typical example of what that death zone looked like. So no claim for the return of ownership was permitted under East German law, and even if ownership had been returned, the location made building impossible. Due to the passage of time, and again through no fault of my ancestors, but rather East German state action, a green area began to sprout. Teltow kept these parcels in an outer area designation after the parliament became aware the parcels were to be restituted. The parcels in question were restituted in 2006. We filed building permissions, and they have been totally rejected. And Teltow has refused to give building permission because the land, they say, is now zoned as a nature preserve. The Nature Preserve Authority refuses to change the designation because Teltow refuses to vote in favor of the parcels being considered building land. Neither offered nor agreed to pay compensation for confiscating contractual building rights. The various German state authorities have engaged in narrow, formalistic application of laws that, for all purposes on the surface, appears to be legal and within their discretion, but in real terms has resulted in the failure of Germany to pay compensation for the confiscation of Jewish building property by the Nazi state, the East German state, and for zoning the building land as nature preserve in the reunified German state. To sum it up, along this sorry road, Germany has failed to acknowledge that this building permission case at its core is about whether Nazi looting and the Berlin Wall will continue to benefit the reunified new German state. Because this was formally a building permission appeal, an appeals court that normally does not consider restitution matters heard it. That court, the so-called OVG, decided, and its ruling was confirmed by the higher courts, including Germany's highest court, to retroactively impose the impossible building rule that my family are required to and failed to comply with the 1934 building requirements outlined in the Nazi development contract with Teltow. The court ruled that we were time barred because we had filed our building applications under modern rules. Subsequently, when we filed under the 1934 contract, the building authority rejected our applications because they were not modern. We are the only persons in Teltow required to absurdly follow the 1934 contract. Well, we have pending appeals against the building authority. So I'm coming to the end of this talk and have to sum up. Again, here's a map of the modern area, and just so you can see what we're talking about, this was the farm compound. This was a formal park. The 10 parcels that we just discussed are right here. There's the border. There's Teltow Canal. We defeated Teltow to obtain this forest, which was also promised as building land in part. Some of it has to be preserved. So, I do not dispute that Germany has a deep and abiding commitment to Holocaust survivors and has paid over the course of its history somewhere upwards of 60 billion. And Germany has a deep commitment to Holocaust education and profound symbolic memorials. And some of you may recognize these photographs. This is Willy Brandt at the Warsaw Ghetto. And these are, in the middle are Stolperstone, which are ways of memorializing individuals from the locations from which they were taken. And then in the last photograph is the center of Berlin, the memorial to the slaughtered Jews during this period in the heart of Berlin. However, when the effective German state action is to deny well-founded Jewish claims for justice stemming from Nazi persecution, then Germany commits serious violations of its basic law and the European human rights conventions and protocols. The Seehoff claims are an example of the bittersweet fruits of the new reunified German process. I believe the overwhelming majority of my claims have been decided properly, but the struggle for this justice was against the delay strategy. There were repeated violations of my rights and German legal procedures, and there has been and continues to be a misuse of building and land zoning laws to deny justice. And this denial raises troubling issues beyond my family. I believe the history of the Third Reich has to acknowledge local history. In large part, the unjust result in the LSG or the land that we've been discussing, the green area cases, comes as a consequence of the now well-documented failures to acknowledge local history. Although Teltow-Seehof 1 dealt with restitution, it could not restore our building permissions. Because different laws and agencies govern building permission, local and state and judicial German authorities have ignored the historical meaning of Teltow-Seehof 1. It holds no water to formally obey rules and laws and procedures when the result is unjust. Accordingly, the Teltow-Seehof litigations pose not only a legal problem, but a moral and historical contradiction to the generally perceived German narrative that taking responsibility for the Third Reich past is accepted, understood, and performed. In 1985, Richard von Weizsäcker spoke in commemoration of the 40th anniversary of the end of the war in Europe and National Socialist tyranny. And he said, our young people are not responsible for what happened over 40 years ago, but they are responsible for the historical consequences. We must help younger people to understand why it is vital to keep memories alive. We want them to accept historical truth soberly. I hope we will not have to wait another generation before the Teltow politicians take responsibility for their history. More broadly, when the rule of law, which appears to be formally correct, causes injustice and undermines a cornerstone of German policy, Germans should take notice and correct their system. So, I come to the end of my talk. Let me end on a personal note. One day, in light of all the evidence, I hope the opponents of restitution and fair dealing will reconsider their views. I hope that my efforts to obtain a full measure of justice will be seen as responsible. I hope that these lawsuits and their history can be an inspiration for and provide some guidance to those who seek justice. What I've learned is that to live my own life, I've had to forgive Germany. And in the words of Nelson Mandela, as I walked out the door toward the gate that would lead to my freedom, I knew if I did not leave my bitterness and hatred behind, I'd still be in prison. Thank you very much.